Judge 22-117, Toro versus Karen Reed. So identify yourself, starting with the comment.
Good afternoon, Mrs. Natalie. Good afternoon, Your Honor. Good afternoon, Mrs. Butler.
Good afternoon, Your Honor. Martin Weinberg on behalf of Karen Reed, who sits to my left, and her counsel, David.
Good afternoon, Mr. Weinberg. Good afternoon, Mr. Nettie. Good afternoon, Mr. All right, Mr. Weinberg, I will hear you when you're ready.
Thank you, Your Honor. May I use the podium?
Of course.
Thank you. Judge, there are two central issues.
Don't know if there's a microphone.
There's not one for amplification, there is one for
If
recording.
I could actually keep your voice up and turn on the mic, please.
Yes, Your Honor.
I just want to make sure I hear it.
At a day like this, I'll keep my voice up.
Okay.
And thank you, Your Honor. There are two central issues that are raised by the motion to dismiss and the supplemental affidavits that have been filed on behalf of Ms. Reed. The first of them is whether or not there is strong and I contend uncontradicted evidence that the jury reached a unanimous decision, even if it wasn't formalized into a vote or into a polling announcement to the court. But it's strong and uncontradicted as a result of the juror declarations that were made through counsel to the court, sworn to by counsel, that the jury reached a unanimous verdict on two of the three counts of the three-count indictment. So the legal issue is in the face of that evidence, whether or not Ms. Reed can again be re-prosecuted for the same offense by the same prosecutor who we contend failed to prove her guilty one, much less 12 jurors in trial of one. And when I address that, Judge, I will make a proposal to Your Honor that's close to the procedural pathway used by other judges in cases similar to this, in terms of just how do we transform representations in attorney affidavits into hard proof that we believe will convince the court, and in fact believe it will convince Mr. Lally in the district attorney's office that that jury, the jury that Your Honor described as an extraordinary jury, reached a decision. It will be consistent with their jury service and consistent with respecting that jury service, that we give at least the jurors who are willing to appear before the court anonymously the opportunity to inform the court that this was a final unanimous decision. Further deliberation, it was a unanimous decision on two of the three counts, and the impasse was in fact on the third count, which was count 2, and lesser includes the manslaughter count. The second of the legal issues that I want to address, and they both together center on the double jeopardy clause, its unique history, and it's discouraging, if not deterring, if not prohibiting, second trials when there's any rationale that would justify the verdict of the first trial, the first jury, or the continuation of the first jury's deliberations, is whether or not, now that we have evidence that the jury was not at an impasse, evidence that was not known to Your Honor at the time that you ordered that they be disbanded and ordered the mistrial, evidence not known to Mr. Lally or the defense, that in fact the note they wrote to Your Honor after the Toohey charge on July 1 was not unambiguous, as Mr. Lally wrote in his pleading. It was ambiguous. It was subject to two constructions. One, that their impasse covered all three counts, and therefore would lead ineluctably to a mistrial declaration. Or two, that the impasse was on one count with multiple lesser included charges, but did not encompass counts 1 and 3. Your Honor didn't know what was in the jury's mind, what was in their mind when they authored a note to the court, neither did counsel. But the issue now, And again, it's in the context of double jeopardy, which is such an historic and important clause that was enacted by our founding fathers to give them some protection against the sovereign, at that point the king, against simply mistry prosecutions that weren't going well. And the founding fathers wanted citizens not to have to face re-prosecution. They understood the ordeal and anxiety and risks of having to prove to a second jury what they had proven to a first jury, which is that they were not guilty. And so the real issue here is legally, what do we do when we now know that jurors are declaring to the court that they believed they reached a verdict of not guilty? What can we do on August 8th, if I've got the date correct? 6 weeks after the July 1 trial that Your Honor presided over, a lengthy trial